Looks like everyone's ready. I'm not sure if I'm going to pronounce it correctly. Is it Geerdes? Correct. Okay, Mr. Geerdes.
Good afternoon. May it please the court. Mr. Bauer. I will be the first to admit that appeals involving the interpretation of rules of civil procedure does not lead to exciting jurisprudence. But this is a rule that is used, I don't know how many times each year, but certainly in the hundreds, if not in the thousands. So I think it is deserving of attention. Quite frankly, I'm somewhat surprised that this hasn't been decided already. What I would like to do is start by addressing the Court of Appeals' rationale for its decision, and then go on to other points which should be considered and which perhaps were not addressed by the Court of Appeals. As I read the Court of Appeals' decision, they based it on two different concerns. Their first concern, or rationale, was that a default notice which is sent to both an attorney and that attorney's client is an unethical communication with a represented party. Their second point of their decision referred to the word notice in the singular and not in the plural. I think the second point is very easily addressed when you look at Code Section 4.1, I believe it's 17, we know that singular includes the plural and vice versa. So the court's fixation on the singular form is contrary to statutory interpretation rules. The ethical concern, I think, is a very important concern because obviously it arises potentially underneath the Court of Appeals decision every time that notice of default is sent. And the rule contains a conundrum on this way, in this issue, because it says if there is an attorney who is representing another person but who has not filed an appearance, they should be sent notice. And it also says in subparagraph A, it refers to the notice to the party. Well, does that mean that anytime you send a notice to a party who may be represented, you're violating an ethical requirement?
Troubled by the ethical requirement because the ethical rule has an exception as required by law. So if we read the rule as requiring notice to the party, then that solves the ethical problem. I'll tell you what interests me is I actually used to practice in Arizona, and we adopted a rule like this while I was down there. And when we adopted the rule, it was worded very similarly, except it made it very clear. It said, a copy of the application shall also be sent to the attorney for the party, so that it made it clear that if the party was represented, a copy shall also be sent to the attorney, instead of the way it is here. We didn't include that language. So what do we do with that?
Reference the Arizona statute, but they reference the Pennsylvania statute, which sounds to me like it must be very identical to the Arizona statute. And obviously, in the Central National case, the Supreme Court went to great lengths to express its favor of the Pennsylvania statute. They recommended adoption of the process contained in that statute. The result of the court's weighing in on that was our present rule of civil procedure, which requires the notice. Therefore, I think that because the Supreme Court favored the Pennsylvania approach, that our rule should be interpreted as being consistent with the Pennsylvania approach.
I wasn't real clear, but what Arizona has is they have essentially the same language under B, represented party, but then instead of saying a copy of notice of intent to file shall be sent by ordinary mail to the attorney for the party, they say shall also be sent to the attorney for the party, which makes it crystal clear. We didn't go with the word also. We came along after Arizona may have looked at their model. Looks like we did look at their model, but didn't include the word also. So what do we make of that?
Pennsylvania model. And we certainly followed that, and I think because we favored the Pennsylvania model, and the court recommended the Pennsylvania model, the result that we have should be construed to be consistent with the Pennsylvania matter.
I'm struggling a little bit with the reference to copy in subsection 3A and B. It says copy in both of them. So it says to the party, a copy of the notice. And then in B, it says a copy of the notice, typically referred to as a duplicate. And so it would make a little more sense to me under your argument if under A it said to the party and then the notice of intent instead of referring to a copy of it, and then in subsection B referring to a copy of it. You follow me?
I think I do, but I disagree with the conclusion. As a practical matter, the way these documents, these notices have been prepared, is that the plaintiff's attorney lists all of the people who are going to be receiving the notice on the front of the notice page, where it says "to" in the standard form, and that includes the clients. It includes the defendants, and it includes any counsel that might be involved. So, and then that is photocopied, and it is sent out. You don't prepare a new, freshly signed original for each one. Some of these debtor-creditor actions may have, 50 different people who are sent the notice. So you don't prepare a freshly signed original for each person receiving the notice. You send a copy, and that's just as a practical matter the way it's done.
Ambiguous?
I don't think it is ambiguous. I think you've got A and you've got B, and you've got the rule of construction, which says every part of the statute is intended to serve a purpose, and nothing should be ignored. And I think obviously what the court had in mind when they did the Central National case is the great word bungle, okay? And what they wanted to do there was to address communication errors, miscommunications. For example, you could have a defendant who might think the lawyer's going to take care of it. You've got the lawyer thinking, I'm not going to do anything until I get my retainer fee. So what do? The way you address that problem is by sending the notice to both. If you send it to just the lawyer, he's not going to do anything because he hasn't received or she hasn't received her retainer fee. And I think it's putting that lawyer in an untenable situation if that's the way you interpret the rules. Now, I'd also like...
It seems to me, maybe this is a question for Mr. Bauer. It also kind of seems to me that if you only require the notice to the lawyer, then you're going to have arguments like you do in the present case where the client says, well, they weren't really representing me. And that just leads to more litigation and cases that go all the way up here on a Thursday afternoon. But if you make it clear you have to notify both, then the issue of whether they were really, that forecloses the client from making the argument, well, this person didn't represent me. So.
Advantages of being an old lawyer is that I was around before this law or before this rule was passed. And I think it's safe to say that before this rule, it was not that difficult to set aside a default judgment, okay? Now, I've never had any luck doing it if the proper notice had been sent because, well, as you just said, there's been this final 10-day notice and you at the very least should have contacted your lawyer or contacted a lawyer and gotten legal representation. That's the whole premise underlying the Central National case, is that the court was tired of dealing with all of these notices to set us, or these motions to set aside a default case. It was taking up a lot of time, obviously. If you're a debtor in that situation and you lose at trial, you sort of have every motivation to file an appeal, which bogs up not only bench time at the district court, but Court of Appeals time as well. I think that if you have to focus on one thing here, is that our established rules of statutory construction call for the determination that the Court of Appeals did not get this matter correct. When you're dealing with the basic idea that all rules and statutes are to be interpreted in their entirety and that no part of it should be considered surplus or unnecessary, that means that you've got to look at both paragraph A and paragraph B and read them together. That means that notice to both need to be sent. Another factor is that the legislature used the word shall. The Supreme Court used the word shall in that order. Shall, of course, means a duty. It seems strange to me that you would impose a duty in paragraph A and then use the word shall again in paragraph B, connoting another duty, but then say you only need to do one of those duties. I think the word shall means something, and underneath our rules of interpretation under Code Section 4.1, shall means a duty, and I think it would be a mistake to somehow say that, well, yeah, you have a duty, but we'll let you ignore it if you can fall underneath subparagraph B. In other words, the interpretation should be considered conjunctive unless it is clearly not conjunctive. If you consider this statute, this rule to be ambiguous, it should be interpreted in favor of giving too much notice instead of giving insufficient notice. Because if you give and allow insufficient notice, you're going to be, and you should expect, a barrage of motions to set aside back as if it were the pre-Central National times. I'm down to about 30 seconds. Thank you for your consideration so far.
And Mr. Bauer.
May it please the court, Mr. Geerdes, it's nice to see you again. I have the privilege of representing Lincoln Savings Bank in this application and now hearing on further review. As Mr. Geerdes set forth and has been articulated in the briefing, the question here is really quite straightforward, and I, like Mr. Geerdes, am a little surprised that this issue hasn't come up before now. I think our panel at the Court of Appeals felt the same way. But the question is simple. Is the 10-day notice requirement in Rule 1.9723 something that must go to both the litigant and their counsel when known to be represented, or to one or the other? The facts here, obviously, there's no dispute that Lincoln Savings Bank did not send a notice directly to Ms. Emmert. That went only to her counsel. We maintain that the Court of Appeals decision was correct on this question of first impression. And that does start with, obviously, the structure and language of the rule that we're looking at. And Justice Mansfield, I think you highlighted this in talking about, I believe, Arizona, and also looking at the Pennsylvania statute that was referenced in the Iowa case we've been discussing. Our statute does not include language that says "and," or to your point in Part B that says "and also send the notice to the attorney." It reads as it reads. And as we argued, and I think the Court of Appeals found compelling as well, the previous section, Section 1.9722, also talks about the notice, singular. And I appreciate that the rules of interpretation dictate, as Mr. Geerdes said, that the singular may mean the plural. But that is the language and the content of the statute that we're looking at, and again suggests we maintain that there's a singular notice.
So one subject that hasn't come up yet, 1.972 sub 3 sub D, the form of the notice, and this refers to Form 1.1901 or Form 10. And if you look at that, it has a line that says "to," and then in parentheses it says "defendant," and then the actual content of it, it seems to be directed almost solely at the party. And so it says, "You are in default," so that has to be the party, defendant, "because you have failed to take action required of you in this case. Unless you act within 10 days from the date of this notice, a default judgment will be entered against you," so obviously not the lawyer, "without a hearing, and you may lose your property or other important rights. You should seek legal advice at once." If this were to go only to the lawyer, that notice would be framed really strangely, right? I mean, it seems as though this, at least, is intended for the party and the party only, and that then B would refer to a copy of this being sent to the lawyer. What do you make of this form?
Great question, and I think obviously the notice itself will ultimately go to the debtor, to the debtor in this case. That's the person that would be in default, not the lawyer. And so it doesn't surprise me that that's the form that the document is written in. I think that, the issue we're talking about obviously is, well, how does that notice need to be delivered? And here, again, our position is we have two subheadings with no connector to say you must do both. There's a delineation drawn between the party.
Does that make the rule ambiguous?
Is it's not ambiguous. We think that it's clear on its face that these are two options for two different sets of debtors.
And if you look at 1.972, it talks about the party doing something. And normally when parties do things, they can do them through their attorneys. So even though our rules talk about parties doing something, we allow attorneys to do that. And so if you were to do some in discovery rules, a party might be required to do something, but their attorney can do it. So if the drafter expected the notice to go to the attorney if the party was actually represented, and you only had A, wouldn't that go to where your interpretation, and so you don't really need B? If you're saying it only needs to go to one or both, or one or the other?
Understood your question in its entirety.
When you see party, when you're in litigation and parties do things, they do it through the attorneys. Okay, so if your position is A and B are alternatives, so basically you're saying A is, if it's an unrepresented party, this is what you do, B is what you do if it's a represented party. We wouldn't need an A and a B if it is an alternative, because if it just said a copy of the notice goes to the party, normally we would expect that to go to an attorney, so you wouldn't need to differentiate.
I see what you're saying. I'm not sure I agree with the analysis, and I may be misunderstanding your question.
Point is, by calling out the party and then calling out a represented party distinctly, it seems like that's going above and beyond maybe, and would support more the other side that that both notices are required.
I take your point, Justice Oxley. Again, our position on this, and I think why we don't think there's ambiguity, and we can talk about the court's analysis if there is we have two items here. And we have to remember the context as well. When this rule was passed, at least prior to that time, there was no rule about providing notice of default. And so we went from that situation to this situation. And again, the court referenced in its 1994 decision the Pennsylvania statute. And yes.
Let me ask you come at this from another angle. If you look at the headings, it says to the party, and then it says represented party. All right. So if your position was right, I would almost expect it to be kind of parallel to the one would say to the represented party, and one would say to the unrepresented party. Or it would be at least to the party and to the represented party. So that lack of parallelism to me suggests that maybe it isn't in either or requirement. You see what I'm driving at?
Not sure I disagree. I'm not sure I agree. I take your point. I think. Yeah. Right. I think one thing the parties probably all agree on, and perhaps the members of this court, that this provision in the code probably could have been written in a way that was clearer. And so I will concede your point, Your Honor, that might make some sense if you concede or at least are willing to entertain our arguments about why our position is supported. I will readily admit, as I'm sure Mr. Geerdes would as well, if we had simply had a and also, or simply delineated very clearly what was going on, we wouldn't be in this issue.
Well, I think we all remember when that happened. But when I was practicing law and the 10-day rule started, I sent out all my notices of default on Thursdays because I wanted to give them the least amount of time. It would run on a Sunday. I could get my order filed on Mondays. We had Mondays judges everywhere. So anyway, there's some chess playing going on, no doubt. But to me, I always felt like that, and I think it's true, that 10 days is there to protect the party because something really nasty is about to happen. So doesn't that make sense that that's perhaps the approach that we should take, is that giving more notice and giving more of an opportunity to actually get the notice is what the intention is?
Well, I think I would generally agree with Your Honor that more notice is probably always better than less notice, but I think the inquiry here needs to be governed by what the language says, the situation that it arose in, and what parties like my client are dealing with when they have to make a decision on how to handle this issue. I know it came up in the discussion with Mr. Geerdes about the Court of Appeals discussing an attorney's ethical obligations, and Justice Mansfield, I think I agree with you. If you think we're just dead wrong on this, there's no problem with ethical obligations here, because the sending of the notice would be warranted by existing law, right? But here, it's not clear how to handle that. And so I think, again, coming out of the 90s and the new rule, going from no rule to some rule that I think we all admit may not be the clearest thing in the world, I think what the Court of Appeals concluded is that dictates in favor of the bank's interpretation.
Interesting that both sides, each of you have said this rule is not ambiguous, and then you each read it a different way. And I think they're probably both fair readings. So I'm a believer in the purpose canon. So if the purpose of the rule is to help avoid defaults so we can decide cases on the merits and avoid the sort of the bungles, and if the fact there's already a default, doesn't that raise a red flag that there may be a problem between the lawyer and the client? So isn't the better rule, the better interpretation to effectuate the purpose of the rule to send notice of both?
I think certainly the better way to avoid default judgments may be to send notice to both. I think the question is, what does the language say? I take your point on the purpose, but I think the purpose was a little more narrow than simply making sure we don't have to be dealing with default judgments. As I recall, the context was there was no rule, and attorneys had been informally letting other lawyers know if it was a client represented, here's the notice. And there was concerns about gamesmanship going on in that. And so the court wanted to be more clear. Obviously, we weren't clear at all, and put in place the rule it did. And so while I accept your point, I'm not sure that the underlying purpose is solely to reduce the number of default judgments that the court is dealing with. I think, members of the court, I have covered what I sought to cover. Again, I think at the end of the day, this is a pretty straightforward question that simply needs resolution by this court. And so unless there are further questions, I have nothing further.
Thank you, sir. Mr. Geerdes, you're going to come back.
Thank you again. I don't know how much this anecdote that I'm about to tell you has anything to do with statutory construction, but I'm going to say it anyway. From time to time, on my way to work, I am presented with a grocery list. And let us assume that this grocery list has 4 items on it: bread, milk, cat food, and bananas. The word "and" doesn't show up there. There's 4 things: bread, milk, cat food, and bananas. Now, what happens if I only bring back 1 of those things or 2 of those things? It depends on the mood of the cat. Ours can get very cranky.
I think the other side argues it's more like the list says Pepsi, Coke. And does that mean just Pepsi or just Coke or both Pepsi and Coke? I think it's a little more complicated. Where I'm struggling a little bit is on this Pennsylvania sort of model question. If the model had language in it that was very clear that it had to be both the party and the lawyer, and our rule doesn't have the same language, does that indicate that we intentionally didn't do that because we had a different view of it?
Not in this case. Specifically, the Central National case, when you look at the facts of that case, it involved an insurance company suing another insurance company and about 4 individuals. The lawyer for the insurance company plaintiff called up the lawyer for the other insurance company and asked if he was going to be representing the defendants, the individual defendants. He said no. So in that situation, the notice sent to the lawyer would do no good because he is at odds with the individual defendants. He's adverse to them. So the facts of the case and the purpose of the Rule of Civil Procedure 1.972 mandate that the notice be sent to both. The worst case scenario is that people get over-noticed, okay? That causes no harm. But if you leave out the notice to the individual defendant, you run the very real risk that the defendant himself or herself is not going to know about it. Like in Central National, the lawyer for the defendant insurance company would not send any notice to the individual defendant.
Get you to scooch by the mic. I just got a note that we can't hear him. Thank you.
And to answer your other point, when I get a list that says Coke, Pepsi, I bring home both Coke and Pepsi. There's no harm in that other than the fact that our pantry might be full for a while. But that's what you do. You follow the list. And in 1.972, there's a list. And I think that to say that one of the items on the list is superfluous and can be ignored is contrary to both the plain language of the statute and, of course, our well-established rules of statutory interpretation. Like Mr. Bauer, I think I've covered the points. So unless there are further questions, I thank you for your time.
Say, as a former practicing attorney, like all of us, and a former trial judge, this is an issue that's going to impact, I think, every lawyer across the state. So, very important issue. Sorry you guys had to be the people to talk about it. Thank you. The case, that's right. The case of Lincoln Savings Bank versus Emmert is hereby submitted, and court is adjourned for the week.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.
David, good to see you again.